Al-Quran, the Last Testament, to get your free pack containing the meaning of the glorious Quran and 10 free publications. Please contact IDCI on 0121 327 2277 or visit www.idci.co.uk. Also available as a free MP3 CD of the complete Quran recitation. We also have a large selection of books for all. IDCI, committed to conveying the message of Islam to every home in the UK. Inshallah.
गिना की हकीकत। हज़रत अबू हुरैरा रज़ी अल्लाह ताला अन्हु से रिवायत है कि रसूल अल्लाह सल्लल्लाहु अलैहि वसल्लम ने इरशाद फरमाया, दौलतमंदी और तोंगरी का ताल्लुक माल और असबाब से नहीं, दौलतमंदी तो दिल की दौलतमंदी है।
Assalamu alaikum, you're watching Just Law, coming to you live from our studios in Southwest London. I'm your host, Saleh Ahmed. In this program we discuss legal matters. You're welcome to call in and participate with us, inshallah. You can call in and discuss with us in 4 languages, in Urdu, in Bangla, in Arabic, and of course, if you prefer, in English. आप हमारा साथ उर्दू में बात कर सकते हैं, अपनारा आमादेर साथे बांग्लाय आलाप करते पारबेन, ممكن أن تتحدث معنا باللغة العربية أيضا, and of course in English. There's no limit to what you can ask, but of course if you ask in a topic that is not familiar with our guests, then they'll give you generalistic answers, or perhaps we'll go away and come back with an answer for you next week. Let me introduce my guest to you. To my right I have Arnab Sen.
Hello.
Who is an immigration specialist. He's been practicing for about 5-6 years as an immigration consultant. And I have Clive Francis, who has been working in criminal practice for about 7 years.
Hello.
So the phone number will come up on the screen after a little, and so you can join us in this program. But before we turn to the phone lines, I'll ask a few questions to our guests to get started. So Arnab, I heard there's a new English language requirement coming in today, 28th of October.
Yes, you were right. Basically that from 28th of October, a life in UK test is coupled with English language test. আমি যদি বাংলা এটাকে এক্সপ্লেন করি যে আমাদের বাঙালি শ্রোতাদের জন্য লাইফ ইন ইউকে টেস্টের সাথে সাথে এখন ম্যান্ডেটরি ভাবে একটি ইংলিশ টেস্টেরও সূচনা করা হয়েছে এবং সেখানে B1 লেভেল অফ ইংলিশ এক্সপেক্ট করা হচ্ছে।
Okay, so for the viewers who understand English, the B1 English test is being introduced today on 28th of October. So in addition to Life in the UK test, if you're making a settlement application, you would also need the B1 level. So when you do make an application, please be careful and check that the English language requirement has been met. Are there any other additional requirements?
Yes, 28th of October is a cutoff date. Those who have sat for Life in UK test prior 25th of March 2013, they still can actually go with that Life in UK test certificate and apply even after 28th of October with that particular certificate. Those who are, I'm talking about those who have sat for the Life in UK test prior 25th of March 2013.
Right, so 26th of March is the cutoff point. If they have already done their life in the UK, then they would not need to do any B1.
Additional. No, they still have to do the English language test, right. But the Life in UK test, as you know, after 28th of October, is a change version. So those who have done 25th of March prior to 25th of March 2013 prior Life in UK test, they can still carry on or continue submitting their application with that previous test certificate.
But they will still need the B1, or?
They still need the B1. The English
So
language is a requirement.
So there's a new version of the Life in the UK test?
Yes, but the English language is mandatory. It is coming with every Life in UK test after 28th of October. And there are certain exemptions for people who are below 18 or jara 18 বছরের কম বয়স্ক এবং and those who are above 65 যাদের 65 বছরের উপরে যে যারা বয়স্ক ভদ্রলোক ভদ্রমহিলারা রয়েছেন তাদের জন্য they are exempted from this test. And also the people who have obtained the leave to remain in this country under the refugee leave or discretionary leave, they are still exempted from Life in UK test.
I see. In terms of other applications for naturalization, does the new English language requirement still apply?
That still applies, and there is also another thing we need to make a note over here is not only B1 level of English is accepted, also ESOL level 1, 2, 3 certificates are also accepted in the place if someone doesn't want to sit for B1 level of English. So Life in UK test coupled with ESOL, like as foreign speakers who doesn't have that much of English language speaking capacity, they can still sit for ESOL level 1, 2, 3 coupled with the Life in UK test.
Okay, that's very good. Okay, as you viewers, you can ask questions on family, immigration, and criminal matters today, as our guests are specialists on those areas. But of course, you are free to ask questions on any topic you like, and we'll try our best to address it. Let me introduce my second guest, Clive Francis, criminal practice for 7 years.
Correct.
What are the latest updates on criminal matters? I heard legal aid has stopped or has been reduced. Some changes?
Yeah, there have been some changes in criminal legal aid. Primarily on the practitioner's side, there have been reductions, but that doesn't affect, people who are entitled to legal aid as such. That has remained the same for a while. Criminal legal aid in the magistrates' court is means tested, and people are entitled as of right in Crown Court criminal matters at the moment.
Right, so legal aid is available at Crown Court level regardless of your income?
It is at the moment.
And what about magistrates' court?
Subject to a means test. I think the limit on earnings is £24,500 or a sum about that figure.
So about 2,000 a month?
Yeah, just anything to that level, probably the person would still be eligible for legal aid.
But I think it's a little unfair because you have a cut-off point. So before that you get full legal aid and after that you get no legal aid?
Yeah, there's no contribution in the magistrates' court. You can be subject to a contribution in the Crown Court depending on your earnings, but not in the magistrates' court. So if you are above the threshold and your matter remains in the magistrates' court, then you would be a privately paying client.
Right. There's been some recent discussion about paying solicitors hourly and how it encourages people to work slower. Would you agree with that in the criminal practice?
We used to, the scheme used to be funded on an hourly basis, and one of the problems with that was not, well, I'm not sure what the problem was, but fixed fees then took over from hourly rates, presumably because hourly rates encouraged, I don't know, maybe it became too expensive, shall we say, to fund the system on an hourly basis. So fixed fees took over. And on the other hand, of course, now solicitors are having to work
much harder to get the same result.
Yeah. On the one hand, you can be overpaid, and on the other hand, you can be underpaid. There's no happy medium in this, apparently.
Okay, viewers, the number is on screen. Please feel free to call in, and like I said earlier, we're able to take your questions in 4 languages, and so don't be shy, speak your own language. And for the English-speaking viewers, we will translate a summary of what's been said in either Urdu or Bengali or Arabic into English, so you won't miss out. Okay, we have our first caller on the line. What's your name and where are you calling from?
Oh, hello. Assalamu alaikum. My name is Samina. I'm calling from London.
Okay, what's your question?
It's with regards to spouse visa applications. I just wanted to know whether the High Court have delivered their judgment in terms of how much you need to show you have in your account, and what's the current threshold, inclusive of current account and savings, what you need to show in terms of figures.
Okay, that's a question for Arnab. High Court case, 13,000, 18,600. What's happened?
Yes, it's all clear. It's on 5th of July 2013. We got a judgment from the Royal Court of Justice, which basically mentioned that the figure 18,600 is clearly an arbitrary figure. It can be 18,000. It can be someone can miss it by earning £18,000 or £18,500, and clearly there is no scope of any sort of compassion in that case. So, which is very wrong that High Court has found, and High Court has actually gone against Home Office for that matter. But now Home Office, when they lost it in the High Court, then they have appealed it further in the Court of Appeal, and the matter is still pending. The court has not come up with any sort of figure or any sort of decision yet. The Home Office, I was recently reading, that have requested the Court of Appeal to expedite the matter further, but it has not been done yet, and they have the Court of Appeal actually accepted their request, and they are looking into that to expedite the matter. But as of now, anyone who is not meeting £18,600, they can lodge the application. Home Office is holding their application. If you are meeting 18,600, well and fine, your application would be granted, just provided you are meeting other requirements. But if you are not meeting the 18,600 threshold, you still can apply with whatever income you are producing, and the Home Office will hold the application until the decision pass. And there is no such time limit that Home Office is guaranteed that they can come up with. So if your leave is expiring, it's better to lodge that application, whatever your partner is earning.
But isn't that unfair? If someone has a spouse abroad and the High Commission is holding their application, surely that is going to just delay matters. I
would say that somebody has to take the courage. Maybe I really expect that some other law firm, and I would like to see that take this matter further for another judicial review, that whether Home Office can hold this application legally like they are doing now or not. There should be a debate in the High Court on this matter.
Okay, from your experience, do we know how many? Are we talking about months? Are we talking about weeks? What are we talking about?
It becomes lengthy when it goes to Court of Appeal or Administration Court. It is not like any other. It's more like any other civil court. It takes a lot of time. To be honest with you, to come up with a figure or with a time frame, it is unfair, because we really know, neither the Home Office knows nor the court knows. But as I mentioned, that Home Office requested the Court of Appeal to take into consideration of the people who are making the application, and their future is kind of uncertain. So therefore, they have taken the request seriously, and they are looking into the matter.
So what will
happen?
Hopefully,
they will come back with some decision very quickly.
So what will happen to people who are rejected on the financial grounds prior to the case going to High Court? Would they be a review, or how would they deal with that?
We hope there would be a retrospective decision, and then in that case, once the decision is passed, like they have done before, they might allow a review. So those who have been refused for the sole reason of financial requirement, I think they should be a little bit more patient to wait for this decision, and they might even go back to their solicitor to lodge a review after this decision comes out.
Because after the changing of the age requirement from 18 to 21, there was a reversal.
Yes.
And then they invited everyone to reapply, and they applied the new rules. So I hope this happens with. Next caller, please. What's your name? Where are you calling from?
Yes, my My name is Ali Raza, and I got two questions regarding immigration. First one is, I came to know there's some change recently in the immigration matters, especially in the family laws. Is that affect like 7 years old human rights, like these matters is changing as well? And the second thing is, how long it takes normal